And all our protest entails is putting up a few tents. Like, that ought to be something that can be tolerated and in fact ought to be protected on this campus. And so a few more tents went up, and when the police re-emerged in full riot gear and lined up to try to get to those tents, the demonstrators who had come out made kind of a human, people linked arms in order to try to put up resistance to the police going in and taking down the tents. And the police response to that was to jab people with batons, to swing at people with batons, to grab people by the hair who are in the bushes. And I mean, people will see that on the videos. It was really, really shocking. And this is one of those things about the law that, that I think is part of what we're fighting around. I think generally when you're looking at questions of police brutality, the way the court posed the question was the force that the police used reasonable under the circumstances in which they used the force? And police experts, when we first started taking this case, there were a number of other lawyers that told us this is a complete non-starter. We don't know why you're doing it. Yeah, we looked at the videos of people being jabbed by batons and pulled by the hair and knocked over and whatnot, but we only saw like 50 overhead swings, and that's the only thing that's inappropriate, and so this isn't, like a viable legal case. And we said, okay, that is just not true, because to us, the question of whether force is excessive or not is a decision that has to be made by a jury, by any community, about what is acceptable for the police to do under the circumstances that are before them. And we have thought from the beginning that we could convince a jury of people selected from Northern California, and our jury pool is huge, and it includes some really conservative areas, that no, it's not proper for police to come on campus and beat Berkeley students who are doing nothing other than holding a peaceful protest action that is causing no harm and should be of no concern to anybody in terms of the danger of it. The university's original claim of why they brought the police in to break up the encampment was that they were worried that there weren't enough bathrooms and people would be peeing on Sproul Plaza and then rolling around in it or whatever, that they were going to be these health and safety dangers that, and in some of the early depositions, they wanted to know, well, how are you going to take a shower? And, if you stayed, where were you going to go to the bathroom? And it was kind of like, well, these were not hard logistic problems to solve if you were on Sproul Plaza. And obviously that explanation that you were looking after the safety of students by beating them in order to protect them against the possibility that they wouldn't find a toilet fast enough, that explanation was a non-starter. And that really meant that the university shifted to what was a more honest position of theirs, but is typical in police brutality cases, which was and is an appeal to racism. And from fairly early on, their case was, we had to do what we had to do to prevent Occupy from coming to Berkeley campus, because we were fearful that Oakland would march on Berkeley and Oakland would take over Berkeley. And Oakland being a code word for Black and Latino youth coming on the campus. That's all this defense is. It's a typical police brutality defense that is wrought with racism And that has worked case and case and case, time and time again, in California, in situations in which the police have gotten away with murdering Black and Latino youth, and they've, at the end of the day, when their stories don't stand, that they thought the person had a gun, that the person was running at them with a machete, that they feared for their lives, that maybe they didn't have a gun, but the police officer slipped and fell and the gun went off 17 times and shot somebody in the back. When those stories really don't hold up in legal proceedings, when people even get the cases to trial, which oftentimes they're dismissed before they even get to trial, the appeal of the defense attorneys for the police is always the same. And it's the following. It's, okay, you may think this officer is guilty of police brutality. And you may think that this murder or this beatdown or this, wounding or whatever of the person that was the victim in this case was not justified, is not justified. But, jury, think about it like this. We, the police, are the wall of defense that you have against the brown and Black hordes of California invading your life. And it's an appeal to fear and prejudice that's extremely nonspecific, and that makes it in some ways more effective. It's a general fear of what will happen if there aren't police there to maintain the separation between the haves and the have-nots, and in particular the Black and Latino communities from the very well-to-do white suburbs. And that appeal has worked. And, it was seeing the jury in the Oscar Grant case accept that police officer's utter bullshit story. And just, all the police are trained to cry in these situations. I mean, they all get acting lessons, and if our case goes to trial, we're going to see a bunch of them cry. It'll be so heartbreaking. Because that's what they always do, but that's always worked. And that's really the only defense. And, okay, we think we can break through that. We don't have illusions in the difficulties of winning, what is going to be almost certainly an all-white or overwhelmingly majority white jury. We think we can win. And in some part we think we can win because these are Berkeley students. And these are the people that the jurors wish that they had as their sons and daughters. So there's a difference because it's a very diverse group of plaintiffs. But we also think that we can win because of how much has changed since 2011 because of Ferguson, because of Baltimore, because there is a sense that these issues now are explosive. And if you can't win justice in a court, well, you're sure going to try to win it in the streets. And when we began this case, and our judge has said this to us repeatedly, if you're coming here looking for justice, you're in the wrong place. The courts don't give you justice. Maybe we can give you some money, but we can't give you justice. And we've said, no, we think we can win justice. And we think in this case, winning justice means not so much a measurement. We'd like to win a gazillion dollars, but it's not measured in money. It's measured in us being able to provide an example for students all over this country that if you stand up and you fight and your administration brings in the police, then keep fighting. Don't fear that will mean the end of your lives, the end of your career, that will make you blackballed in this society. Don't submit to the hype. Stand on what you believe in. And we want to convey to all of those administrations, we can put you on trial. We can publicly humiliate you. We can show your lies, and we can make you say them publicly. In this case, all of the university administrators, that include the chancellor, the, executive vice chancellor, and then a bunch of other vice chancellors claimed that none of them saw the videos that had gone viral from the afternoon when they made the decision to leave before the evening police action. And all of them claimed that they left the campus at about 7 or 8 o'clock, having no idea what was going to happen in the evening. And one of them left then because her son had an Eagle Scout meeting. She was she's the director of media relations for the university. She said she never saw a video. The first time she saw what happened was at the 11 o'clock news when she and her son came home from the Eagle Scout meeting, and she was completely aghast. Now, how credible is that? Zero. I mean, either she should have been fired, because she was a complete incompetent idiot, but she is not an idiot, and she is not incompetent. She was, however, told by some lawyer that you can protect yourself from liability if you're not there to see the arrest, to participate in them, if you're not there to see the police brutality. And so all the administrators say, we didn't know anything. What? You're saying we knew what was happening, even those that say that they talked to students and the students told them what was happening, say they didn't know what was happening. It's a case that if in most police brutality cases, it's the police that look like liars, in this case, it's going to be top administrators, most of whom have left because they were forced out, that are going to reveal the absurdness of their stories and the arrogance by which they think they can get away with this. And so from our standpoint, yeah, if we can win on this, we can provide protection for other students. We can make administrations hesitate before bringing the police onto campus. And we can convince families all over this country who have been told repeatedly, you can't win justice, even when your husband or your child or your mother or your father were killed by the police. Yeah, you can fight and you can win justice. And we have other police brutality cases that we have in the state of California. And I think for those people, this case is so important because it says, it answers the question, can you fight and win? Or does fighting just mean that you're going to be subjected to more police harassment and brutality, and at the end of the day, not even achieve justice? So that's kind of an overview of the case. I'll just say one other thing about it. I think, or two things. One, our great strength in this case is our people. It's our plaintiffs. It's the 21 people who are pursuing this case. And they are, in my opinion, so incredibly compelling and likable and different and honest, and that we have all kinds of things. I tease people about some of these things, but when you see the videos, you'll see a vet with a big red purse. I mean, she does not look like somebody who was in there for a fight. I was like, there's, one of our people looks like a church lady. And Max is our accidental plaintiff. He's, was sitting on the steps of the library, and the police were like, you have to leave. And as he's leaving, the police are marching up, and it's either, run at the police or join the protesters, or decide, okay, this isn't my fight, and I'll try to hide somewhere. And he made the right decision. And for that, he was struck by the police. And, Ben is a super duper he's a research physicist. And their claim about Ben was that he was trying to grab a police officer's baton so that he could strike him with it. And, Ben because Bennett can be a very angry person, but he's not, insane. So that was not, what he was contemplating. And Anthony, I think you'll see in the video, he's one of our plaintiffs that takes an incredible beat down. And it's kind of like, we're just going to stand and fight. And so that's the first thing. And the second thing is, at the end of the day, this case is purely political. It isn't about the law. If you're the judge in this case, and you're making the decision whether or not to dismiss our case, to dismiss our First Amendment claims or our excessive force claims or some people's claims or our false arrest claims, you're making that decision based on a set of political calculations, not on a set of, of legal considerations. Because any case in which a reasonable jury could be on our side based on what the evidence is in the case, any case that a reasonable jury could decide for us should go to trial. That's supposed to be the legal standard. If you think a jury could find for us, take it to trial and, allow the people to decide. That's the standard. And we think, a reasonable jury could decide for us on every single one of these counts. And at the end of the day, this is a case about credibility. Who do you believe? Do you believe the police that the reason why they did what they did was because people were kicking them repeatedly, that they were like, that our protesters were like the Rockettes? And they're just, kicking away, just kicking. And none of it's captured on video. But all of it happened, supposedly, and that's what caused them to act. Do you believe that? Do you believe that the administration, that they can get away with saying, oh, but we weren't there, so you can't charge us with false arrest, and, and you can't say that we were responsible for the brutality, and this had nothing to do with the substance of the protest, even though repeatedly we've allowed encampments to take place on the campus and done nothing. And as one of the administrators said, because they seemed really unpopular, like they were trying to win nothing and they were going nowhere. Well, if your claim is that the only time you take them down is when they might be successful, that's clearly a violation of free speech. That's selective enforcement of your own policies. So I'll stop there. I think what the judge decides will be determined in large part by how much of a buzz we can get going and how much support there is for this case moving forward. And so, this is, we're holding this not just because we want to tell you about what happened, but because we want to involve you in the movement. And it's through the building of that movement that we can win. Last December, the UCB administration called the cops out to beat students who were part of the protests around Michael Brown's killing in Ferguson. And they have learned nothing. As of this point, they think they can get away with that whenever and wherever they want. And it behooves us to build a movement that can make it possible for people to fight for equality, to fight for justice, to fight for a better society than the one that we live in now, and not to have a fight that has the chance of winning be met with armed police, with the stuff that we generally associate with a police state. So I'll stop there. Thank you.